Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, February 5. Before I get started, I just want to note that we have students here from Pace Law School, so they wish apparently to become lawyers. So we should be on our best behaviors so that we are not dissuading them from their career choice, okay? So as I call the calendar, please ask for the time that you need to get out the salient points of your arguments. Please keep in mind that we have read your briefs. We're fully familiar with those arguments. So please, just the salient points of your arguments. People v. Aldo Jorge Rodriguez. That matter is submitted. Arita v. FDS Associates. Did you wish time on rebuttal? Appellant?
Yes, please, Your Honor. I respectfully request we'll say
Sure. 5 and 2 and 5. Matter of D children. That matter is submitted. Morrisy v. Morrisy. Yes, you are the appellant. And how much time are you requesting? There is no respondent, so it would only be you. How much time are you requesting? Certainly, 5 minutes. Patchel v. Goldman. 5, 2, and 5. Castle Village Owners v. Geraldi. Did you wish time on rebuttal? 5, 2, 5. People v. O'Connor. That matter is submitted. People v. Tavares. That matter is submitted. Cologne v. the City of New York. 5, 2, and 5. JDS Construction v. Cooper Services. I'm sorry? 6, 2, and 6. Excuse me, 6, 2, and 5. Matter of Lala. That matter is submitted. People v. Zwingman. That matter is submitted. Friedman v. Garnet Wines. 5, 1, 5. Cook v. New York City Housing Authority. 5, 2, 4. North Flax LLC versus Belkin, Burden, Goldman. 5, 2, 5. People v. Johnson. That matter is submitted. U.S. Bank v. Gordon. That matter is submitted. I'm sorry. Oh, who?
Original request 15.
I'm sorry. U.S. Bank v. Gordon. You are Gordon. And how much time are you requesting? You're the respondent, so there's no appellant. You still wish to argue? It's up to you.
Well, yes, I still want my 15 minutes.
Okay. Okay, 4 minutes. People v. Marquis. That matter is submitted. Lamb Pearl Street v. Renaldi. Who's the appellant? You are, who's the respondent? I'm sorry. You're Lamb. And how much time are you requesting? And who are you, sir?
I'm to introduce the pro patrice attorney who will be arguing today.
Is that?
That is counsel.
Okay, thank you. I'm sorry? After we finish the calendar call, you're welcome. People v. Joseph R. That matter is submitted. Fort CRE 2022 is submitted. The first matter for argument is Arita v. FDS Associates. Don't worry about it. I'll get it now. Yes, whenever you're ready.
Okay, I apologize.
That's
Good
okay.
afternoon, Your Honors. May it please the court. My name is Kelly Griffin-Fromm. I'm here from Resnick and Lewis, and I'm here on behalf of the appellant, the third-party defendant, the City of New York. This is an issue that I know this court has been grappling with recently involving the civil RICO litigations. In this particular case, plaintiff alleges that he fell from the ladder on January 16th of 2019 while installing television cables in the wall of his place of employment. It was an unwitnessed accident. He then filed suit less than 2 months later on March 13th of 2019. He ended up having surgery and having numerous appointments along with law firms that we ultimately found out were embroiled in the civil.
The medical records that are record here show that he actually had an X-ray done at Montefiore that shows an actual fracture of his elbow.
It does, but he...
And notwithstanding the RICO concerns about the law firm and certain healthcare providers that are in this record that have referred the plaintiff for surgery and subsequent surgery, not the original elbow surgery, and physical therapy, et cetera. Nothing in this record right now even comes close to suggesting that the plaintiff engaged in any kind of fraud.
Or even knew about it.
Well, Your Honors, with all due respect, I mean, I think that's the issue here, is that all of the medical records that you're talking about were done by providers at facilities with
Oh, I
imaging.
thought that he went to the hospital.
He did initially on the first day, but after that, all of his providers were facilities, doctors, and a law firm that were named in the civil.
Was it Montefiore that actually diagnosed his fracture?
Correct, it was, yes, Your Honor.
So that's why my colleague was stating that it's clear he had a fracture.
He may have had a fracture, but it's not clear that the surgery was necessary and all treatments that occurred after that point. All appointments in medical...
It was a comminuted fracture, a displaced comminuted fracture of his elbow.
Right.
That
Your
pretty
Honor,
much
again,
requires...
part of the issue... I apologize.
That's okay. First of all, Linares and in Franco, this isn't our first rodeo here. So the question becomes is, could you be entitled to discovery? That's something for us to think about. But why would there be a basis to have to stay the trial or vacate the note of issue? And moreover, my understanding is that in August, the Supreme Court granted summary judgment on the labor law case. So that meant that on searching the record on summary judgment, a court of law determined that the plaintiff fell from an elevated gravity-related height and awarded him that, right?
Yes, but again, with all due respect, going back to the very beginning, the civil RICO litigations are involving staged accidents or accidents that were coordinated to get to the point of where we are now in the litigation. So the entire accident from the beginning could have been staged, and we did not find out about this until after the filing of the note of issue. So it's our opinion,
Counsel, how do you justify the fraud allegations when we've decided many cases already that you wouldn't have any justifiable reliance? What was your reliance? You relied upon the plaintiff's statement? What statement, was there a misrepresentation? How can you prove fraud without justifiable reliance?
well, I mean, in general, the courts had disallowed complaints to move forward if they are premised on fraud. So if this entire case was premised on fraud, meaning...
Counsel, please answer my question. I asked you about reliance. I understand that you're making allegations, but there are two cases that cited in the briefs. Actually, one of them was one of my lower cases, was my case, quite frankly, so I'm familiar with it. I think it was Linares, and I cited that there's no justifiable reliance. How do you answer that question?
The justifiable reliance was relying on there not being a fraud that was perpetrated in the first place going on.
Is it reasonable to rely upon the plaintiff's statements when you're the defendant?
It's reasonable to rely on the plaintiff's medical records. It's reasonable to rely on plaintiff's law firm. It's reasonable to rely on plaintiff's narrative at the time of how it happened. All of this came out after the fact. And the note of issue, you know, our argument is that the note of issue is basically being used as a shield at this point to protect plaintiffs in a position such as this, because in looking at Franco, for example, which I actually am the attorney on Franco, so I happen to be familiar with that. Okay, so in dealing with Franco, this court found that the information was material and necessary and allowed the defendant to go through and have a continued deposition. So
But denied the allegations of fraud, right? They didn't allow you to amend.
but we didn't seek to amend, even here in this,
Did seek to amend.
not in Franco, we didn't.
I thought you did, but I'll have to
In
go
this
back.
case, we did. In Franco, we didn't. In Franco,
I don't recall, but I think you did.
in this case? We did.
This case you did.
Yes, we
Okay,
absolutely
fine.
did. But I mean, the crux of what we're really looking for is discovery. Keep the note of issue in place, don't amend, it's fine, but we're looking for discovery because we feel that, as with Franco, a note of issue doesn't make it suddenly immaterial or unnecessary to get to the bottom of it, and we don't
Thank you.
think.
You have time on rebuttal.
Okay, I apologize. Thank you very much for your
okay.
time.
Good afternoon, Your Honors. May it please the Court, Jonathan D. Moran for the respondent. I respectfully submit, Your Honors, that nothing in this record comes close to establishing any element of a cause of action or defense of fraud. There is no
We're
evidence.
really not talking about a cause of action for fraud in the sense that your friend is trying to recover damages for fraud. What we're really talking about is that doctrine of fraud on the court under CDR Crinsace.
Well, I suppose I use that language because that's the language of 3016B, which says a cause of action or defense of fraud must be stated with factual particularity. There is no factual particularity present on this record to establish a material misstatement made by the plaintiff at any point in time, or to whom it was made. And to Justice Hagler's point, there is no evidence that there was a reliance on those statements or on anything.
Counsel, let's say we agreed with you.
Okay,
Why shouldn't the city be permitted to conduct further limited discovery?
sure. Well, the essence, and that was a play in Franco and in all of the cases concerning these spurious, unrelated federal actions concerning RICO, right? In any case where there is a post-note of issue demand for further discovery, you have to make a showing, right, of unusual and unanticipated circumstances justifying compelling that post-note of issue discovery from taking place, and you have to show that it's reasonably calculated to lead to material and admissible evidence at trial. Here, there is no such showing, and I respectfully submit that these unrelated federal RICO actions, which don't involve this plaintiff, don't involve this accident, and don't involve the defendants at bar, does not rise to the level of meeting that burden. I would point out that in Broughton in the Broughton case, in Linares, the unrelated RICO actions, which are at this point unproven civil allegations made by insurance companies against a whole swath of
Again,
plaintiffs'
why
attorneys.
wouldn't the city be allowed to depose plaintiff to see what, if anything, he knew
Right.
about his attorney's RICOs?
Right. Your friends, the city's argument is that their argument is that the whole accident was staged, and that therefore they should be entitled to question at least the plaintiff as to what occurred, what he knew about these other accidents that the law firm and others had been a part of, and whether or not that somehow impacted or impacts this particular case.
And to answer that question as directly as I can, in Franco, there was a holding that there was a substantial likelihood that the plaintiff would have knowledge concerning the purported fraud. Here, that's their argument. I agree, that's my friend's argument. However, there is nothing to
So why not just why can't we just ask the plaintiff? Why not just conduct depositions of the plaintiff and ask the plaintiff what he knew or what he did not know in terms of the RICO action and in terms of the other, the complicity of the attorneys, et cetera?
Your Honor, I would submit that posing those kinds of questions to a plaintiff when there's been no proven allegation, no charge, no conviction, or anything of the sort to suggest that there even was such a cabal or collusion or scheme, which are the words that my colleagues on the defense bar like to throw around, is not in keeping with the law of this department or any department. You're not allowed to just make an argument and go on a fishing expedition without some factual showing of relevance to the case
It's more
at
than
bar.
a fishing expedition, right?
Yes.
Because we do have, we do know that there are allegations that the law firm, et cetera, were engaged in some type of fraudulent activities.
Allegations, Your Honor. Nothing's been proven, and in fact, all of the RICO actions are the subject of motions to dismiss. One has already been dismissed with prejudice. Another one, there's a decision that should be coming down shortly. It's already been orally argued in front of Judge Gershon. That was the first RICO action that was made. And I would submit, Your Honor, that if your honors look at the unrelated federal actions and just see exactly what they are and who they're brought by, I think the lack of merit and the lack of scruples on the part of those who have brought them is readily apparent. They are brought by insurance companies with a demonstrative history of committing fraud on their own. The CEO of Roosevelt Road was the target of an attorney general investigation, settled for $3 million for committing workers' compensation fraud. So I would submit that nothing has been proven to demonstrate that the attorneys named in these suits have committed fraud, that the doctors have committed fraud, and it's a completely unsupported argument to seek another deposition, and it should not be allowed, especially in the absence of a fraud claim or defense.
Thank you.
Thank you.
Thank you, Your Honors, for the additional time. First, I would just like to point out the one case I am aware of in federal court that was dismissed on the civil RICO was only against a law firm, not this law firm, and it was dismissed on jurisdictional grounds. There was no finding on the merits of whether there was fraud or not, if my memory serves correctly. So that case was dismissed, but it's not relevant, in my opinion, to what we're talking about right now. Again, we're talking about very severe and very substantial prejudice to the appellant if the appellant, at a minimum, is not allowed to have even just a continued deposition limited with the plaintiff. There's no prejudice. Plaintiff can't claim there's prejudice, and there's not. But this case is the quintessential case that matches up with the civil RICO litigation actions. You've got an unwitnessed labor law case that happened on a Saturday afternoon. You have a lawsuit that was commenced less than 2 months after the accident occurred. You've got a law firm who's named in it. Outside of the initial hospital visit, every medical treating facility and doctor and imaging facility is named in these civil RICO litigations. And at a minimum, the note of issue should not be used, as I said, as a shield against the appellant because it happened to be filed before all of these lawsuits came out. But again, there's absolutely no prejudice, and plaintiff has not, or the respondent has not even claimed that there's any prejudice. There will be nothing negative that happens if we're allowed to pursue this on the basis of just a limited deposition of plaintiff at this point. Unless anybody has any questions, I thank you very much for your time today.
Thank you. Thank you both.
Thank you.
Morrisy v. Morrisy.
Good afternoon, Your Honors.
Good afternoon. Whenever you're ready.
Yes, Your Honor, I bring the case to the appeal court because the divorce
Oh, if you could speak into the mic and keep your voice up, please, so we can hear you.
is better.
A little bit, yes.
Okay, so I have a divorce case in Supreme Court under the Judge Katz, and he disposed my case because it was a previous divorce by my husband. I tried to consolidate the case, so I make a motion, but he disposed the case for the reason he started the case before in Queens, Supreme Court. I submit all the documents. When I opened the case, I didn't know he started the case before. And what I found out in Queens is the certificate of dissolution.
So the Queen's case is sealed, is that correct?
No, the case under Judge Katz, which I'm here, is
No, Katz is, who's in Queens?
Michelle Titus. the
Right,
judge.
so what happened with the case in Queens?
So the case in Queens unfortunately continued. It's been postponed until today, and it's no review, any maintenance or anything. So the reason I'm appealing this court is
No, what
because-
happened to the Queen's case? Wasn't that case dismissed and sealed?
No, it's not. But when I submit the papers in Supreme Court with Judge Katz, I found the certificate of dissolution was under fraud. It's a lot of perjury. They had to amend the documents. I had to correct the lawyer. He did the requested judicial intervention. We have a family case for spousal support, it's still pending. But he say we didn't have cases pending. So the whole submission of the divorce in Queens, which is the reason why Judge Katz closed my case here in Manhattan, because he assuming the other proceeding is not under fraud. So only I ask is a discovery in my case. Still, we have a pending spousal support. The case is not even they didn't even review my case. So the lawyer, what he did is mislead the Judge Michel Titus. He submitted the requested judicial intervention forgetting all the cases, which is a spousal support, is no any review of spousal support, and he tried to just commit fraud. And this is what I bring the case here, because I would like the Judge Katz continue with my case, remand the case for do a discovery in Manhattan. Unfortunately, that passed already a year. So the fraud is continued in Queens. At this point, it's even alteration of the documents. And I had a copy of the certificate of dissolution when he say he never was married previous mine when he was married for 20 years. Not only that, when he did the requested judicial intervention, he already knew he had the spousal support pending, which is still, until today, is open.
Did you have a hearing on January 6th
Or
last
9.
month?
Or January 9?
Was it January?
We did, but this
In
is the
Queens, in
yeah.
Queens.
This is the thing, because
So is that a yes or no?
yeah, it is a yes.
And what happened?
We had the inquest, but since day one, March 2024, the lawyer misled Judge Titus, and I can prove that because I correct
No,
him.
so the question is, the inquest began on January 9. What happened on January 9?
Well, she basically closed my case.
That's
No,
what
she did-
that's what I thought. I asked
But she
whether
did- she did
I'm
not
sorry.
close my-
Let me just finish.
Yeah, I'm sorry.
I had asked whether or not the Queen's case had been closed,
It's not closed yet. Actually, she didn't sign. This is important.
but she didn't sign it. The judge didn't sign it, but it was dismissed, was it not?
No, we did inquest, and she granted the divorce, which is fine, but she did not review the maintenance. And that is the huge issue because we still have pending the spousal support.
The problem was the Queen's case was pending when you filed the action in New York County, was it not?
Indeed was, but the issue here is the discovery neither court have been reviewed. And unfortunately, Judge Katz left the lawyer misled him with fraud and perjury. It's in the documents because he had two different certificates of dissolution. He forgot his client was married for 20 years. And he reminded I was married for twice before. So it's a lot of incongruence and different fraudulent statements. So I would like that if you allow me to discover it in Manhattan, even if I lost the case later. But it's unfair for me because the lawyer even closed the case dead. When he put the notice of issue, he didn't wait for the 30 days period. If someone reviewed, they will find the fraud. Just only one discovery is all what I asked, not even win the case.
Okay, thank you. Thank you very
Thank you.
much. Patchel v. Goldman. Yes, please proceed.
Good afternoon, Your Honors. May it please the Court, I am Charles Scott, counsel for the appellants, plaintiff appellants. Before the Court is an issue of the validity and enforceability of a postnuptial agreement entered into by two spouses. This was a second marriage for
So
both.
the post-nup stated that the property would be split, right? The wife would have interest in the property, right?
Exactly.
It would flow to her, and then she would have the ability to put it in trust or dispose of it the way she wanted to.
So what the agreement
The way she
provides
deemed
for
proper,
is
yes.
precisely that they provided an alternate method of distribution of their marital assets. This was a second marriage for both. Each had children from the first marriage, and the thread of the agreement is that on the death of the first to die, the surviving spouse would have a life estate, and that person's half
She would have the right to sell, exchange, or transfer any
Yes.
of the marital property.
As is true with all life estates.
Right, and in
Your
the
Honor.
event the property was sold, one half would be paid to the children,
That's right.
Michael, Sherry, and Paul, right?
And if it wasn't sold, the children receive their father's half interest in that property upon the death of the surviving spouse.
But didn't paragraph 7 expressly require each party to execute a will giving force and effect to that agreement?
But it also said that each party shall execute a will to that effect. Now, what's important, Your Honor, is that the agreement isn't conditioned upon making a will. It doesn't make the agreement subject to the making of a will. And in point of fact, Harold made a will. And
Right,
his
but
will-
Harold,
He didn't,
go
sorry,
ahead.
go ahead.
But Harold's will, he specifically disregarded the provisions of the post-nup.
No,
He
honored-
failed to include in his will any provision transferring one-half interest in the apartment to the wife Joanne's children upon his death.
But only if she survived him, and that was not the operative event. He predeceased her. And so his will complied precisely with the terms of the agreement given the operative event. In point of fact, it would have been Joanne's will if she survived him, or if she predeceased him, that would have provided for his life estate and the remainder to her children. The point is, Your Honor, that these parties were represented by the same attorney. That same attorney who represented them with regard to the making of the postnuptial agreement also represented Harold with regard to the making of his will. That same attorney also represented Joanne with regard to Harold's estate. She's the executor of Harold's estate. And as executor of Harold's estate, she accepted the terms of Harold's will and all of the benefits provided therein. And in point of fact, on 3 occasions, her attorney wrote to the children confirming their half interest in the house, their father's half interest in the house, confirming Joanne's life estate in that half interest, and confirming that they would receive.
So your position is that that Harold, the fact that he didn't comply with paragraph 7, or you're arguing that he didn't have to comply with paragraph 7 of the post-nup?
Well, Your honor, my argument is that he complied with the facts as they existed at the time of his death. He predeceased her.
Paragraph 7, but paragraph 7 says that he was supposed to execute a will which included 1/2 of the apartment of Joanne's children in the event Joanne predeceased him.
Your honor, there's an overarching issue here that I think needs to be addressed, and that is the fact
Isn't
that
that what paragraph 7 said?
it does, but the will also.
And in his will, he breached that. He did not do that. Is that correct?
But that was not an operative fact at the time of his death. Her will would have provided with him with a life estate and guaranteed her children's rights to the remainder.
So essentially, sir, are you saying that he did breach paragraph 7, but the breach wasn't material?
Precisely, Your honor. But also, Your honor,
Counsel,
if you
how
look
do
at
you
the
address the condo deed being tenants by the entirety? How do you break up a tenants by the entirety without some specific intent?
because the agreement was subject to Domestic Relations Law 236, which authorizes the
there was no
parties to
divorce,
contract for an alternative method of disposition.
I'm sorry, I didn't mean to cut you off.
My apologies. Your-
There's no divorce here. The domestic relations law is not implicated at all.
Well, no, 236 applies to prenup and postnuptial agreements, which authorizes the parties to provide for an alternative disposition of their assets without the need for having to retitle those assets. In this instance, the parties provided for that alternative disposition contractually by agreeing that each would have a life estate and the other's half, with the remainder to go to their respective.
But again, his will totally disregarded the provision in the postnup.
And so did Joanne's will, Your Honor. The will in that.
But that really is of no consequence because, again, his breach was prior to, he still breached it before she passed.
But Joanne didn't claim a breach until her 2020 will was brought to anyone's attention. In 1986, two years, at the time of his death, her attorney, Goldman, again, who was his attorney, wrote to the children confirming their interest in the house and saying that now that Joan had survived him, she would be making a new will confirming their right to the remainder of the property on her death, the right to the remainder of her life estate. So just as Joan didn't have a will at the time of Harold's death, which memorialized the paragraph 7, which Harold is being held to here, neither did Joanne's will. And just as Joanne, because wills are ambulatory, just as Joanne had the right to amend her will.
This was, there was a letter that was unsigned that said Joe intends to execute a will?
Yeah, this is a will from Ms. Goldberg, Joanne's attorney,
The letter.
who was the attorney that represented them on the prenup, who was the attorney who prepared Harold's will, who was the attorney who apparently knew the contents of Joanne's will, and at least to the extent that it didn't provide for the event that Joanne would survive Harold. just as Harold's will didn't provide for the event that Harold would survive Joanne, and said that Joanne would now make a new will memorializing the terms of the contract now that it has turned out that she survived Harold. But,
You have time on rebuttal. Thank you.
thank you, Your Honor.
Yes.
Good afternoon, Your Honors. May it please the court. My name is Olivera Medenica from Dunnington, Bartholomew, and Miller on behalf of respondents. I think it's important to put the case in perspective here. We have two adults who are now deceased, who decided to enter into this postnuptial agreement, who decided to purchase a property as tenants by the entirety, and decided not to implement the terms of that postnuptial agreement. Harold clearly did not abide by the terms of that postnuptial agreement.
I'm sorry,
and
but
neither did Joanne.
was his breach of paragraph 7 a material breach?
It absolutely was. It wasn't just paragraph 7. His will gives a life tenancy to Joanne, period. And if Joanne passes away, then she gets to keep 50%, and 50% of the money goes to Harold's kids. But the fact of the matter is, she had a life tenancy. So if she decided not to sell the property, as exactly what happened here, and she dies, and let's say Harold's will was in effect, her kids would get nothing. It's an absolute breach of that postnuptial agreement. I mean, it's absolutely clear here that her kids were cut out of getting a piece of that apartment. And once that breach occurred, it's black letter law in this court in EXRP 14 Holdings that a material breach of a contract excuses the non-breaching party's performance and precludes the breaching party from bringing a claim under the contract. And here, Harold's will did not comply with the postnuptial agreement.
So your friend argues in part that Harold's breach was not material because he predeceased Joanne.
No, the consideration, I disagree with that, Your Honor, because the consideration here is that each party would provide for the kids of the other. That was the purpose of the postnuptial agreement. And so they acquired property, and in fact, the postnuptial agreement talks about property in general, not just this condominium. If you acquire it, yes, you will provide for my kids. That was the consideration, but that never occurred.
And so Harold's will totally cut out Joanne's children.
1,000%, Your Honor, 1,000%, because she stayed in that apartment. It's in a beautiful area of Manhattan, highly valuable. She stayed in that apartment. She had no reason to leave. And once she died, according to the terms of Harold's will, her kids would get nothing. So that constitutes absolutely a material breach.
What if she had sold it?
If she had sold it according to the terms of Harold's will,
right.
the monies could be, although I think the terms of that will are not, phrased in the most clear way, but it appears you could interpret it as her keeping 50%, although it doesn't exactly say that. But the kids would get 50%, or it would be placed in trust for the benefit of the kids. I do want to address the issue of breaking the tenancy by the entirety into a tenancy in common. And the Court of Appeals in matter of Yoli, Justice Kay, the late Justice Kay, set out the rules in terms of how to actually break title to tenants by the entirety in 3 ways, by certain definitive acts, which is, one of them is a conveyance, another one is a judicial decree of separation, and the third one, if there is a very clearly expressed intent pursuant to GOL 3-309 to break that interest.
Right, there has to be an express statement reflecting an intent to alter the party's tenancy by the entirety.
That's correct, Your Honor. And that intent is missing in the postnuptial agreement. And so there's nothing inherently in the act of entering into the postnuptial agreement that broke that tenancy. Once Harold died, because Joanne was a tenant by the entirety, she received the property, which is why there's no,
Counsel, why isn't the expression in the post-note nuptial agreement, if you take away the words, "and each party shall execute a will to that effect," let's just abolish that for a moment. Why isn't that an expression? It just wasn't executed, but why isn't it at least the intent of the parties to make it a tenants in common based upon that expression?
I think, of course, Your Honor, if we take away that language, I think that's one additional reason it would not be an immediate transfer of the property. But it could be interpreted as, we'll do something in the future, we'll transfer the deed in the future, perhaps.
It doesn't say that each party shall receive and accept. The language is mandatory, not precatory.
But Your Honor, if we compare the language in this case to some of the other cases cited by my opponent, the facts are really factually distinguishable. In some of the cases, we see very clear language, such as the parties within X amount of days will contact the board and will request that the shares, or it's very clear language stating what the parties are supposed to do immediately. And none of that was present here. And I do want to say that in the postnuptial agreement, that language was general to all property, not just that condo. So there really is some vagueness there, and not that immediate language that the tenancy was separate. If I can just make one.
No, actually, your time is up.
I
Thank you.
apologize. Thank you, Your Honors.
Your Honor, if this postnuptial agreement isn't self-executing, and if it doesn't by its terms pursuant to 236 break the tenancy by the entirety, then the agreement in its entirety is an absolute nullity, because the only way that it can become effective is if it breaks the tenancy by the entirety and creates co-tenancies with the rights of
Can you answer your friend's argument that there's no immediacy, this is like speculation, there's no, it's not mandatory, and therefore we should not give it effect? How do you answer that question?
Well, we cited 3 cases in our brief, Your Honor, for the proposition that postnups are effectual, enforceable in and of themselves. That's the Baker case, the Peabody case, and the Vanderbilt case.
Paragraph 7 doesn't talk about the condo itself, right?
I'm sorry, Your Honor?
Paragraph 7 doesn't talk specifically about the condo.
No, but nor does the agreement say that it is contingent upon or subject to, or that the will is a condition precedent or condition subsequent. And what we have to recognize here, Your Honor, is that one attorney was representing these people throughout their marriage and the making of their wills and the administration of Harold's estate. And to conclude that Harold's will, which was drafted by Ms. Goldman, did not comply with the agreement would be to conclude that Ms. Goldman violated her professional responsibility to her other attorney, Joanne. And that argument is, carries out throughout the entire estate administration, because it was Mrs. Goldman who induced the children to waive their right to a judicial account.
Paragraph 7 talks about jointly held property. So wherein it doesn't reference the condo specifically, that was jointly held property.
Well, it was a tenancy by the entirety, Your Honor.
But isn't that really the same? It's the same thing.
But a will cannot break a tenancy by the entirety. Even if they both made wills in strict compliances with this agreement, it would not have broken the tenancy by the entirety. The only thing that can break the tenancy by the entirety, among other things, is a contract, this contract, pursuant to Domestic Relations Law 236, which provides for an alternate disposition of their marital assets.
Thank you. Thank you both. Castle Village Owners v. Geraldi.
Good afternoon, Your Honors. May it please the court, my name is Ingrid Manovitz, counsel for Castle Village Owners Corp. For over 2 years, the respondent, Dr. Geraldi, the proprietary lessee of apartment 77, has prevented Castle Village from entering her apartment and repairing a leak which is actively damaging the ceiling of the apartment below. The motion court erred in denying Castle Village summary judgment and permitting Castle Village to make these necessary repairs for at least 3 reasons. First, there is no dispute of material fact that there is a leak and that leak originates from an issue in Dr. Geraldi's shower pan that needs to be fixed. Second, the unambiguous...
Was it HPD? Someone came in and said maybe there wasn't a leak or it was an issue in terms of the leak?
Yeah, HPD did come in. Dr. Geraldi submitted links to videos.
Right, so HPD came in and said that the leak was non-existent, right?
HPD didn't do an inspection of the shower pan. What HPD did was come in, based on the videos, what HPD did was come in, look at the shower floor, and say, not issue a violation. And that makes perfect sense. You can't look at a shower floor that's intact and see the shower pan. The shower pan is installed under the shower floor.
And didn't Mr. Motto, in support of your client, actually do tests to determine if there were problems with the shower pan?
Yes, Your Honor. Mr. Moda did a couple of different things. He went into apartment 77. He opened an access panel where he could see light coming through. He's got 30 years of experience providing plumbing services. That's an indication of either a gap or a crack in the shower pan. He then proceeded to run the shower in that apartment, go into the apartment below, could see that the ceiling of the apartment below was getting wetter, went back up into apartment 77 through the access panel, could see that the wood supports around the shower pan were getting wetter as the shower was continuing to run.
So essentially, your position is that the conduct of the board of directors of the condo is subject to the business judgment rule, correct?
Yes, that's one of the points, right? That there's no dispute of material fact. It's a co-op, not a condo. There's no issue of material fact that there is a leak, that the board has deference under the business judgment rule. There's no evidence of self-dealing, bad faith, fraud here, and that the governing documents between the co-op and Dr. Geraldi give the board the right, or give the corporation the right, to enter the apartment and make the repairs. The repairs to the shower pan are the lessee's responsibility under the proprietary lease. However, the lease language provides that if a shareholder lessee fails to make repairs, that the corporation has the right to go in and make the repairs for them.
So the Supreme Court found that there was an issue as to whether they were needed at all, whether the repairs were needed at all. I guess in part based upon HPD's report or what have you, stating that there was no leak. Supreme Court also found that there was an issue as to whether or not the petitioner, whether the respondent was being singled out somehow.
Yeah, the Supreme Court got it wrong. You know, there are photos of water damage to the ceiling of the apartment below. There is sworn testimony and affidavit from the resident of the apartment below. There is a sworn...
Who also filed various complaints concerning the water damage, the tenant below.
She did, yes.
He or she filed numerous complaints as well.
Yes, yes. You know, and then there's the testimony of Mr. Moda, who did all of the testing that I just described, Your Honor, as well as, you know, an affidavit from the property manager about this ongoing issue.
So your respondent basically takes the position, or your view of the respondent's position is this is all about the gas piping that Dr. Geraldi is unhappy with.
Yes, which has, yeah, there's no evidence of any singling out here.
Well, the thing is that it is kind of unsightly, right, to have that gas piping in the living room or whatever room that is. I mean, it is unsightly to sit in that room and have it there.
You can't see the gas piping, Your Honor. So first of all, the gas piping is not at issue on this appeal, but I will speak to the gas piping. The entire complex had their gas pipes replaced.
Well, that was the other thing. Although it wasn't that the respondent was the only apartment that had it placed in the way that it was placed. All the other apartments also had it placed the same way. So you can't really. The argument is hard to be made that she was somehow selected, right, and no one else.
Correct. There were offsets in the piping, so the piping couldn't just go completely vertical from one apartment to the other, because the apartment located directly above Dr. Geraldi's apartment, it would have required the gas pipe to go literally through the kitchen counter, right? So the pipe had to be transferred, turned in one way, snaked and then continued up. And that happened in multiple apartments. The pipe is not actually visible. It was concealed in a drop ceiling. The apartment looks exactly how it was prior to the gas replacement work because the apartment, they were able to conceal the pipe as it turned in an existing drop ceiling.
Thank you. You have time for rebuttal. I was going to say if you wanted to be seated, but I guess we wouldn't be able to hear you through the mic.
Right. Thank you,
Okay,
Your Honor.
thank you.
Thank you. So, so my name is Guillermina Geraldi, and I am the respondent appearing pro se. So first of all, there are a lot of things that need to be decided, and that's why I think that Judge Frank was correct in denying summary judgment. They never proved the emergencies that they used to be granted this injunction. There are 7 HPD reports that you can access online. They never found any leak, any mold, or any crack.
Dr. Gerardi,
Yes.
I assume that you're familiar with evidence-based research.
Exactly.
So
Yeah, I'm a scientist.
I
so
understand
know.
that. So that being the case, I saw the videos that you took of the HPD inspectors. I didn't see them do any kind of forensic analysis.
Oh,
determine
it's the same thing that they saw.
Just give me a second. I saw them look at the floor of your very beautiful bathroom and look at the bottom of your shower and say, oh, I don't see anything.
They went to the side panel, that is the number 6 and 7 inspection, and they didn't find anything. And also, they are blaming a crack under the tiles that can't be seen. And the last video that is in the court from this inspector didn't find anything. He even said that the shower pan can be not seen from a little drawer this small. And they did actually the same inspection that these people are from the government. They have no financial interest. Mr. Mota is a handyman that his own boss said that he actually unclogs drains. He has no DOB license. He has been working for 30 years. I mean,
He's
without.
a plumber.
I'm sorry?
Isn't Moto a plumber?
He's not a plumber, Your Honor.
He did
Not at all.
plumbing. He did plumbing. But
No,
but
he
how do we
doesn't have a license, a DOB license.
how do we reconcile all of this with the fact of the photos from the apartment
Those
below?
photos were never confirmed. They came 2 years later. First of all, the owner of apartment 67 never allowed me to get in and see for myself or my plumber. And why would she do that? Her insurance rejected the claim because of
Well, you didn't want them to come into your apartment.
I'm sorry?
You prevented them from coming into your apartment at some point in the beginning. You.
No, look at the.
They stated that they attempted to come
Oh,
into
they
your
can
apartment.
say whatever they
Excuse
want,
me.
but actually there's a trail of emails.
Well,
with
excuse
Ms.
me,
Antonio.
one second. They do state that they attempted to come into your apartment a few times and you denied them access.
I even did repairs myself. I removed tiles myself, and we sealed the bathroom.
Ma'am, they said you let them in twice and then you stopped letting them in. Is
Right.
that not true?
No, it's not true. They
So
can
you
see-
always allow them to come into your apartment
Yes,
when they
until-
wanted to?
Yes, until I discovered that there was something fishy. They did not let us see the leak,
Well, it states
So
here,
when you discovered that something was fishy, you stopped letting them in the apartment?
but that was after the injunction.
Okay, ma'am, but you stopped letting them into the apartment, correct? When you found something was fishy.
Well, no, I did it after the HPD said that there was nothing to repair, so there was no.
no,
really
because it
reason.
states between October and December 2023, they attempted to reschedule access to the apartment and you rejected all attempts until January.
that is not
excuse me,
true.
Until January 2024.
I was the one that actually, being a doctor, called Miss Antonia, said, are you going to repair it? There's black mold. And the resident below is 80 years old. So as a doctor I was really concerned about that. And all my emails in the court system show that I was the one after the injunction. They never did anything. They just.
So ma'am, under the lease and the house rules, you are required to repair the leak or grant access for them to.
I did
You're
both.
saying there is no leak.
Well,
And
there's
therefore
the-
you didn't, ma'am, listen.
Yes.
You're saying there was no leak for me to fix and there was no need for them to come to my apartment. Is that your argument?
No, the argument is that they came several times, they never found anything, then I had to call them back because they said that there was black mold growing. And that was the point where I called HPD.
Ma'am, she just argued that Matza went into your apartment, saw some light, let the water run, went down to 6-7,
And you-
saw that the ceiling got wet, and came back up.
Do you imagine what happened? This was 3 years ago. Mota said that it was in March 2023. If every time that I open my shower, the ceiling gets wet, we are two. We shower 4 times a day, 2 in the morning and 2 in the afternoon. That ceiling would have collapsed.
Well, they also stated that when you were out of the apartment,
How do they know that?
I don't know, but there's
do you know-
also, excuse me, there's also a statement here that when you were not in the apartment and therefore not using the shower, there was no leak.
Well, when I leave, you know what I do? I leave my plants inside the shower. That's an old trick. And I am away a lot.
With the water on?
Yes, of course.
Okay.
That's what I do.
But what I'm not understanding really, and maybe it goes outside the record, is if you have an issue with mold and the apartment below.
No, it's the one below, the one with the mold. That's why. I don't have any mold.
And you have no issues.
No, not at all. And
Why not just allow them to fix it? I'm not.
Why they are going to destroy my whole bathroom is there's no necessity.
Is that
They
what they
never proved
said?
it.
Did they say that they would have to destroy your whole
Yes, and I
bathroom?
have to pay for it. And then they sent me some cheap tiles to replace my marble bathroom, and they were actually desperate about doing that, but because you know why?
So you can repair it on your own, right?
I did.
And there's still a leak.
Well, I don't know. They never let me in. That is very suspicious, isn't it?
Thank you.
So I have, oh, sorry, I couldn't.
That's okay. Thank you so much.
I'll be very quick. HPD did not do a forensic analysis like Mr. Mota did, and as I
Well,
described.
Mr. Motor, according to respondent, Mr. Motor is not a certified plumber.
He doesn't have a master plumber's license, but he has been doing plumbing services for the building for 30 years, 13 of which as an assistant super and employee of Castle Village, and 17 prior working for a plumbing contractor. So he's been familiar with and working on the plumbing at the Castle Village building for 30 years. Assistant supers and supers diagnose issues like this all the time.
Is there something in the record, maybe confusing cases, where you gave her the opportunity to vacate the apartment and so that the repairs could be made?
Yes, she was given the opportunity. The corporation was prepared to go in, do the work, pay for it, because it's the only bathroom, or I think it's the only full bathroom in the apartment. There was an offer made to put her up into a hotel, so she
Right.
had access to a shower, et cetera. Yeah, all of the arrangements were in place, but the access was denied, and
The access was denied
correct. And
more than once.
yes,
Is it my understanding that Judge Frank, in a May 23, 2025 order, actually ordered access, that Dr. Geraldi had to give access? Why would the court have to order access?
because access was denied.
Okay, so that means she wasn't cooperating.
Yes, Your Honor.
It was reversed that injunction.
Thank you. Thank you both.
Thank you.
Cologne v. City of New York. Yes, you may proceed.
Good afternoon, Your Honors. May I please the court? My name is Melissa Press on behalf of Plaintiff Appellant Nereida Cologne. This is a slip and fall case on the sidewalk in front of defendant's property, specifically in the portion of the sidewalk where defendant had a special use. The special
Driveway.
use,
You're referring to the driveway?
that is correct, the driveway. Respondent will argue that the plaintiff did not fall in the portion of the sidewalk where the driveway is located. However, I would like to point the court's attention to record 589, which is the photograph of the location of the accident, which shows that the curb cup length does include the portion of the sidewalk where plaintiff did indicate during her deposition that she had fallen. She specifically states that she fell more or less with the shadow of the guy is what she stated.
She stated that she slipped and fell near the entrance to the driveway.
No, Your Honor, she stated she fell, not slipped and fell, indicating that
Slipped and fell near the entrance to the driveway.
the record states that in her plaintiff's deposition that she fell, not that she slipped and fell. In other words, indicating where she landed, not where she slipped.
But my point was, it's near the entrance to the driveway.
That is correct, Your Honor.
So your position is that the fact that there may have been a storm in progress is really irrelevant here then?
I'm sorry, Your Honor, may you repeat the
I'm
question?
sorry. Your position, or really your friend is going to argue that the court was right because there was a storm in progress, and the defendant who owned that area didn't have to do anything in terms of shoveling or throwing salt out, correct? Is that your position?
It's not, Your Honor. So in reference to the storm in progress doctrine, it is our position that there was in fact no storm in progress during the time where my client fell. If
Is
you
that
take-
because the weather records were for an area far removed from
That
the
is
accident
correct,
site?
which is not probative of the condition of the location of accident. Defendant cites, well, misplaces by citing the case Jaboski, but Jaboski is only 1.3 miles away. Meanwhile, they're only providing information or weather station information 6, 9, and 11 miles away from the location of accident, which is not probative of the condition of the accident. But if the court was to find that the lower court was correct in allowing or making it admissible that these weather stations were indicative of the weather conditions of the location of accident, our argument would then be that if we take a look at the record on page, 390 through 392, we would see the certified weather records for LaGuardia Airport, which is the closest weather station defense provided, which is 6 miles away from the location of accident. It indicates that no appreciable amount of snow had fallen since 4 p.m. So instead of what defense will argue that they had until 11 o'clock in the morning of the day of the accident, the argument is, or our position is, that defendant had until 8 p.m. the night before to actually clear the snow, because there was no appreciable amount of snow during that time frame.
But you're also arguing because of special use.
Defendant had a duty to maintain the sidewalk in a safe condition, Your Honor. Okay, and then point 3, which basically—
I'm sorry, what was the failure in their prima facie showing with respect to the special use?
Well, they're indicating that the portion of the sidewalk where plaintiff fell was not part of the driveway. But then again, I will point the direction to the court where it shows in record 589, the photograph of the location of the accident, where you can take a look at the curb cut, which basically shows that the portion of the sidewalk where the plaintiff does indicate that she fell, landed, is actually part of the curb cut length. And I would like to make one more point, which is the lower court erred in shifting the burden to plaintiff because it failed to establish its prima facie burden and entitled them to a summary judgment that there were no tribal issues of facts.
You agree that there's no statutory duty? Can we agree on that?
I'm sorry, can you repeat that?
I'm sorry, there's no statutory duty. You
That is
agree?
correct.
Okay.
That is correct.
Thank you.
I'm sorry, can you repeat the question I'm sorry, Your Honor, I know you said thank you, but
It
when
is
you
correct.
mentioned—
There's no statutory duty based upon the special use.
Okay, yes, thank you.
Good afternoon, Your Honor. May it please the court, my name is Kevin Merton, representing the defendant respondents. Essentially, Your Honor, our positions outlined in the brief is that there is no exception to Section 7210 that the plaintiff can rely upon to impose liability upon us. The argument that she cites 589 in the record, if you clearly, even if you buy the argument that there is a curb cut there, plaintiff indicates that she fell where the guy's shadow is. There was a gate immediately behind there, a fence, excuse me, and there would be no way that there would be a car that would go over that portion of the driveway.
Well, how did you establish a prima facie case that the condition was not created or exacerbated by the special use, i.e. the driveway?
Well, Your Honor, I don't think it could be possible because, again, you know, where she indicates that she fell, there would be no way that a car would be going up that way, Your Honor.
But I thought your client did concede or state that the driveway was used for a car. She just did not recall the last time her husband, I believe she said it was her husband,
Yeah.
used the driveway, the last time he drove, and the last time he used the driveway for the car.
He did say that, Your Honor. She did say that, Your Honor. That's exactly right. But again, if you look at the actual photograph that was put in the record, Your Honor, you would not go into that driveway in that curb cut area. You would simply, it would be to the right of it. That's what we put in our brief.
Well, we don't know. And also the photo that is in evidence, I think is it a Google map?
It is, Your Honor, yes.
Yeah, there's no snow, it's totally clear.
No, I know
I
that,
don't
Your
know.
Honor, but the plaintiff testified that she would have, she fell where the guy's shadow was.
But when
And
she
that
was
would
shown
be-
when she was shown the Google photo of the accident scene, she pointed to an area right next to the area where the cars were parked, didn't she?
Where the cars were parked, yes, where the cars were parked in the street, exactly, but not using the driveway. What I'm suggesting to you is that the curb cut is in an area where you would not drive a car because there is a fence immediately behind that. There is no, so what I'm suggesting to Your Honor is that there is no proof that there was any, it's speculative, there's any proof that there was any reason, that there was any person that drove over that area which would have caused an exception to the 7210. I also would like to address the argument with regards to the other portion of the.
Well, why would it be speculative? Your client didn't testify, well, no, that's not, when my husband did drive or when we did drive into the driveway, that's not how we would enter the driveway.
And whether she fell right outside where the cars were parked or right next to the spot, she was still squarely on the driveway's apron, wasn't she?
She was not on the driveway's apron. She was on the sidewalk by the driveway's apron. Yes, Your Honor.
Right, by the driveway's apron.
Yes, but again, you know, with regards to that, Your Honor, it would be totally speculative, in my opinion, that someone would drive in that area where the fence is located, and the only area that you would drive into the driveway would be to the right of the area where she fell.
But sir, you have the obligation as the movant to make a prima facie showing through evidence in admissible form, right?
Exactly.
And you can't point to gaps in the plaintiff's putative proof.
I understand.
So what is Marshall Forrest, your evidence in admissible form that demonstrates that this the special use didn't cause, create, or exacerbate the dangerous condition?
The only thing I can suggest to Your Honor is I can only say that as I've stated before, which is that the only reason that you would drive into the driveway would be the area to the right where the gate is, clearly not where the fence is.
Isn't it true that your client, Ms. Marsicano, did not recall anything whatsoever about this driveway other than to say that her husband drives there? Didn't give any details whatsoever.
She knew nothing about it.
So what witness do you have to make out the prima facie, other than Ms. Mariscano?
I don't have any witness other than
So
that.
then how do you meet your prima facie?
I prove the prima facie. Again, I can only suggest to Your Honor what I stated before.
As my
That's
colleague
only what I
said,
have.
you're pointing to gaps in the plaintiff's testimony rather than pointing out as your prima facie case that there was no special use of the sidewalk, or you caused or created or exacerbated the condition. So it doesn't even, until the prima facie is met, there's no need for the plaintiff to oppose that motion. Isn't that correct?
Yes, but I suggest to you that I believe that the prima facie is made out. I don't think that is speculative.
Tell me how.
The only way I can point it out to you is how I did, Your Honor. That's it.
Thank you for being honest. I appreciate it.
Yes.
Thank
okay.
you. You have time on, rebuttal?
If Your Honors don't have any further questions, I will rest on the brief.
Thank you both. JDS Construction v. Cooper Services.
Good afternoon, Your Honors.
Good afternoon. So this is now JDS 4.
That's correct,
We're
Your
up to 4. We do have a limit here.
I hope that we do. But,
Okay, I hope we've reached it.
so, Your Honors, I'd like to, may it please the court, George Soteris and Associates for the appellant Copper Services. The first issue I want to address is the mechanics lien dismissal, which we submit the trial court erred in dismissing as time barred.
Yeah, but you never extended it. The statute is clear, and to rely on the vacature of a default as a result of an earlier appeal before this court does not mean you get a pass with respect to the liens.
But at the time that we would have had to either extend or foreclose the lien was, quote, declared and adjudged invalid. So it's an impossibility that I could show up before Judge Borak and say, extend the lien that you held was invalid. I'm going to foreclose the lien that as of today, Judge, is invalid. The only recourse is you got to move to vacate the default, which this court did ultimately. And that moment in time, Copper was restored back to the status quo ante because when an appeal is granted, and in full in this case, Copper's liens were then in effect. It was as if that default never occurred. And when Copper was held in default, it still had 10 months left. This case is exactly analogous to another case that I dealt with. It's in the record. It's my case, New York Professional Drywall, 3rd Department. And what happened there was the summary judgment was granted against the mechanics lienor. The mechanics lien was immediately dismissed. Up on appeal, the court reversed, and we had to go back down to the trial court. Unfortunately, in that case, the county clerk didn't just reinstate the lien immediately. We had to make a follow-up motion, and of course, the 3rd Department agreed that you go back to the status quo ante as long as your liens were timely filed in the first instance, and that's the key here. Our liens, and there's no dispute about this, were timely filed. I could not imagine showing up before the county clerk or a judge in the trial court in Manhattan and say, extend the lien that you already dismissed as invalid. You can't do it. And I would be thrown out of the court, I think instantly, if not sanctioned for doing so. So, you know, the mechanics lien issue, yeah, the statute is clear, but what happens when a mechanics lien is dismissed in the course of litigation, which can take many years, and then reinstated upon appeal? Of course you have to go back to the notion that it's valid. Otherwise, you'd have chaos. I would have to effectively go and file mechanics liens while this honorable court is considering an appeal that's sub judice. I would have to file an extension of lien in the county clerk's office based on an adjudicated invalid lien at that time. So the entire system would be chaos if this court...
Counsel, let me explore that a little further. Isn't it true that there was a default here prior to the extension of the lien? Is that correct? It was valid?
Yes.
So it was filed, I believe, on 9/11/20, right?
The liens were filed in September of 20. They were extended for one more year, yeah.
So you defaulted on, I believe, sometime in June of 2021. And then you waited until after the lien already had expired to move.
That's incorrect.
No?
What happened was the Copper Services was about to file an extension of its mechanics lien. It didn't know.
Counsel, when did you move? Didn't you move October 27th?
Yes, within the 1 year.
2022, and the lien expired on 9/7/22?
It wasn't expired because there was no lien on that day.
Counsel, when would have the lien expired?
In September of 2022.
And when did you move to vacate?
In October.
A month later.
Yes, but Your Honor, it's very simple here because how could I have possibly foreclosed or extended that lien on that day? It's
You're not
impossible.
understanding my question. I'm saying, why didn't you move earlier to vacate the default so that you would have had a specific amount of time in order to have that lien extended?
Because Copper found out at or about that time the liens were expiring. And that's the key here. Its attorney, and this is part of the first decision, but the attorney committed a law office error. And once Copper realized, wait a minute, I don't have a valid lien, that's what triggered it. And that was the moment in time when, and we still had time to file within 1 year under the CPLR 317 and 5015. We still had the 1 year. And by the way, if Your Honors hold that, in effect, Copper had to do something by that second anniversary, then you're completely abrogating 5015 and 317. What happens to the 1 year rule?
Is there any case law in the First Department that provided for an extension non-pro-tunc after the expiration of a lien? Because I couldn't find a case.
There is no case, but Your Honor, just to be clear, that's assuming, you're assuming that the lien was effective. But 10 months earlier, the court had already invalidated the lien. So how can you possibly even do anything on the basis of an invalid lien? It doesn't really make logical sense. And then you're basically depriving Copper of its right to move to vacate within the 1 year. So it's our position.
You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Andrew Bourne from Cohn Ziffer, Frenchman and McKenna on behalf of the respondents here. I think Your Honors hit the nail on the head. This is the fourth time we've been here. And now we're talking about mechanic liens that were originally filed in 2000. The legislature granted tradespeople such as Copper some powerful protections, mechanic liens and related rights such as those, to ensure that they are paid for their work. But with great power comes great responsibility. They exist only with strict compliance with statutory deadlines. And here, the statute, Lien Law 17, is clear. To extend the lien a second time, they'd already extended it once, to extend it a second time, they were required to go to court and get an order from the court. There was nothing preventing them from doing that under the statute. That's what the statute says. The statute is crystal clear.
So, counsel, how would that be possible if the case was dismissed already at that point in time? How would they go back to a court and say extend it when it didn't exist?
Very easily, the same way he did 3 months later, 2 months later. They did go to court. They just went to court late.
So, counsel, when did they go to court to extend it? I thought that they only went to extend it after the default was vacated by the appellate division.
No, Your Honor. So what happened was, and the timeline I think here is crystal clear, and I'll give you the record citations. Copper filed 10 mechanic liens on September 11th, 2020. That's at record 535 to 55.
Right, so they would have set to expire September 11, 2021.
Correct.
And then once as of right through September 2022.
Correct. They filed an extension in September 2021.
Right.
That's at the record. It wasn't until October 28, 2021 that the court found them in default.
Right.
And they were in default at that time. However, they didn't move to vacate the default order until October 27th. That is 2022. After the liens had expired under the statute. They had an opportunity under the statute if they wanted to attempt to continue to lien. Now, granted, I don't dispute that it could have been a fiat accompli, that the court probably would have denied it, but at least it would have given them an appealable paper to bring up here for this court, then to say, you know what, let's see what happens with their default. Let's see what happens. But that's not what they did. And the drywall case actually didn't address this at all. That dealt with a willful exaggeration ruling that was then overturned. It had nothing to do with whether or not the party failed to go and get an extension. And the reason, and we put this in our paper, there's a reason for this. This impairs title. And the marketability of title here is important. And so the legislature has balanced these interests. There's the interest in the tradesperson in getting paid on time.
Can I ask you the same question? Is there any case in the First Department that would extend a mechanics lien past the expiration non-pro-tunc?
Not that I'm aware of. There's nothing in the First Department that I'm aware of other than the First Department case law that says these statutory deadlines are strictly enforced. We put that in our papers. And that goes throughout all of this. And it's in all our papers. I know.
Does that leave someone such as your friend in an impossible position? They have either a valid initially filed lien or an extended lien, and then they're, unbeknownst to them, the lien is invalidated or struck by a court, and now there's a hole. They feel that they think, ignorant maybe of the court's order, they think they still have a valid lien. Is that a blind spot now? Because how can they resuscitate that lien when they come in after the lien has been invalidated to move to vacate?
Well, respectfully, I don't think it is a blind spot, and I think it rests on the fact that they did know about their liens. They were fully cognizant of their liens. There's the affidavit.
Well, they knew about the liens, but then the judge grants the default judgment, and in the course of doing that, invalidates the mechanics lien, right?
That is what the order said,
So
yes.
now there's no extant mechanics lien. Let's assume that the judge is completely wrong to do that. I'm not saying that he was wrong here, but hypothetically, the judge is completely wrong to do that. Now, where does that put someone such as your friend? What position does that put them in? Can they resuscitate that previous lien that was valid up until the moment the judge struck it?
We respectfully submit no, because they had the opportunity to at least, and I see if I can answer the question, I see my time is up. They would have the opportunity they had the opportunity to timely come to court within the framework of the statute and present that issue to the court. But they failed to do so. They waited until it was too late.
Do we look at all to the fact that there was a default? You moved for default in June of 2021.
We did. You guys.
So is that of any consequence, the fact that there was a default because they didn't respond, they didn't answer?
Well, respectfully, we submit no, because we're talking two different things. And when the default was vacated, when this court vacated that default, it said that it may have meritorious defenses to claims, but that doesn't mean, and they are pursuing those defenses, but that doesn't mean that they still have the right that they failed under the statute to fulfill, to enforce their lien rights, whatever they may be. The statute is clear about what they have to do. I see my time is up. If there's no further questions, we'll rest.
Thank you.
I just want to address the word that...
So, Counsel, I just want, at the time that you moved to vacate the default, that was in October 2022. Could you have also moved to extend the lien or make any motion as to the lien?
There would be no reason to, because if, as we were successful, then the liens are reinstated because the invalidity determination is reversed by this court, and we're back to the status quo ante. But I just want to...
Counsel, why couldn't you do it an alternative? Say that I want X relief, as your friend just mentioned, and I also want, alternatively, you have relief of extending the lien.
Look, there may be many different ways of framing the relief, but the ultimate one that's at issue here is a proper one. There could be two ways to do it, or three ways to word an order. I've seen orders many ways drafted. But I want to address the word that Your Honor used earlier, which is expiration of the lien. And I think that's the misnomer here, because the liens didn't actually expire. In theory, they would have expired had the lower court not, quote, adjudged and declared those liens invalid. And that's the key here. That's the intervening.
Why not move to reinstate the lien when you move to vacate the default? You're an attorney. We like motions.
Well, Your Honor, I think it goes
Right,
back to what Judge...
that was my question. That's what I do not understand.
And that's the same question that Judge Hagler just asked, I think, because you could do those two things, but you could just do one of them. I could supposedly have maybe moved to reinstate the lien and move to vacate the default, or the same effect would be moving to vacate the default and then be restored to the status quo ante. And that's what happened. I think you could do it three different ways.
Your argument is that you had no remedy, that you stated that you could not go into the county clerk's office or what have you in order to extend the lien. But there was a remedy, which there appears to have been a remedy, which you didn't take advantage of.
Well, I think that there are probably multiple remedies, but we did take advantage of one that is very valid, and that is 5015 and 317, which says you got 1 year, and we moved, and it's undisputed within that time. And by the way, if we accept this decision as it is on the mechanics liens, then it completely vitiates this court's determination vacating the default. What would be the point of vacating that default as the mechanics liens? The mechanics liens would be held invalid. I think it's just how unfair that is. While the appeal sub judice, and we're exhausting our rights.
So when you moved to vacate the default, what remedy were you seeking? Simply vacate the default?
To be restored, yes, to be restored to the status quo ante. That's the result of any appeal.
And automatically the liens are back on.
Yes, because they were still valid. We still had 10 more months to foreclose at that time. So there was nothing else to do at that time other than simply move to vacate the default, because I can't imagine that I could show up before any of the judges on this panel and say, judges, you have invalidated the liens, which I'm here to now extend, and
So
that's
when
the
the
absurdity.
prior panel of our colleagues reversed and vacated, what specifically did they decree in the decretal paragraph in the decision?
Oh, was that the case that I was on?
I apologize. I don't want to misstate it. So
I think it was my case.
Oh, was that yours?
You were on number
It was
two.
me and Marty.
You were on two.
I
We're
do know
two.
that the
I'm three. On two. Oh, I have two.
there actually is no decretal paragraph in the.
Yeah, there is.
It just said, we determined that you had a reasonable excuse to support the motion to vacate the default judgment, correct?
Yes, but the entire decision entering the default was reversed in its entirety. So, you know, I know that in reading appellate decisions, not every single issue is addressed specifically and ordered perfectly, but I think the import of that is really clear, is that you go back to the status quo as if the default, which was improperly issued and was erroneous, as this court found, you go back to that moment in time. Otherwise, what's the point of appealing anything? Your rights would be expiring while appeals are sub judice.
Maybe be different if you have filed a motion to reinstate the lien and been denied, and then we would be here.
Or even move to clarify, to state that now that it's been, the default has been vacated, that it should also state that the liens now have full faith and effect for however period of time.
I think there's a lot of ways to word the relief ultimately, but the avenue that, or the remedy here is one of probably a few ways to get there, is a proper one. And to go back to something counsel, my colleague said here, the import of mechanics liens, and those rights are important rights, and to cast them aside because there may be a gap here and it may be a slightly unique.
So I don't recall whether this question was asked before, but are there any cases that you are aware of where there were liens and there was a default was vacated, and that meant that the liens now were back in effect and had full faith?
I could not locate a case exactly on point with these facts, but I do know from practicing 20 years in construction and dealing with liens that when they go up on appeal and they are reversed, the liens are reinstated as long as they're timely in the first instance.
Yeah, I think that we normally do we state that, because I think that that's normally the remedy, or that is part of the remedy that's being requested. But we'll take another look at it.
One more, just quick.
Sure, go ahead.
Just this conversation stimulated something with me here. Is there any analogy with a notice of pendency, where a notice of pendency is struck by a trial court, and then on appeal, the appellate court disagrees with the trial court, reverses? I'm wondering if there's an analogy there, and if, you know, whether that helps or hurts you.
I think it's probably an analogous circumstance, because the same way a list pendens has to be renewed every 3 years.
We don't want the gap.
Yes,
So
and
it's.
I'm not aware of, as I stand here today, of any such cases. I'm happy to research it further.
Thank you both. Friedman v. Garnet Wines.
Good afternoon. May it please the court, my name is Andrew Costigan. I represent the plaintiff appellant, Jeffrey Friedman. And this is a fairly straightforward case. It arises from Dr. Friedman's attempt to buy a 23-year-old bottle of.
Well, he did purchase something, did he not?
Well, he got something. It wasn't exactly what he asked for, but he did receive.
But he waited 6 weeks to ultimately open the pretty bag that the bottle comes in, right?
That's right. So it came in a box. Inside is a sack. Inside the sack is a bottle. The bottle's wrapped in plastic wrap. So, you know, he looked in what was delivered, and the sack itself says that it's Pappy Van Winkle 23-year-old bourbon.
Counsel, why didn't he open the sack? He paid $3,890.09 for that bottle. Why did he wait 6 weeks to open that sack?
Your Honor, he was waiting until he had something to celebrate with his family.
He could wait to drink it.
Yeah.
But if I spent $4,000, I'd be darn tootin' looking at it when I got it right away, right?
Okay, but I do think it's fair. He looks, he sees a sack. The sack says, it's a velvet sack and written in gold is Pappy Van Winkle 23-year-old bourbon. And he trusted that. And then when it came time to open the bottle, he saw the bottle was in fact 15-year-old Pappy Van Winkle. And I think these are good questions. I certainly understand the court's.
I mean, counsel, if I buy a Gucci bag for $5,000, when it gets to the house, I'm going to open it. I'm not just going to look at the sack that says Gucci on it.
Your Honor, I think these are very fair points, but I ask you to keep in mind
The whole focus of fighting with the bank and the whole issue of your defamation claim that they called your client a liar, how hard would it have been for him to take the bottle, go to the liquor store on Lexington or whatever it is, show them this is what I got? But he didn't do that. He's arguing with the bank, and then they proceed to show their records in the context of a dispute, a chargeback dispute.
And there is a good reason why he didn't do it, and that's because Garnet was accusing him of being a thief. So showing up at the store with a bottle that said 15-year-old Pappy Van Winkle would not have satisfied them. And I would like to remind the court that this is an action that was dismissed. It was decided under 3211. So, you know, I think these questions of credibility that come from the delay.
Well, with respect to the legal principles underpinning the defamation, this was a libel, right? This was a written statement.
Yes.
Okay. So the test is whether the allegedly libelous statement subjected your client to hatred, contempt, or aversion.
Well, it's whether it tends to.
Right, tends to, right.
Tends to, which I think points to sort of the intrinsic nature of the statement as opposed to the result.
It's intrinsic as well as contextual.
As well as contextual.
Okay.
And there is, of course, a long line of cases saying that accusation of a felony larceny clearly is defamatory per se.
Would we need to employ some inferences to get there? Because he did say liar, but I didn't, nowhere in the statement that I read did he expressly or explicitly accuse him of a crime or of a felony, specific or otherwise a felony. So is there too much being left for inference there? The question of whether he was committed a crime in the course of.
I would say not, Your Honor. Any potentially defamatory statement should be understood in context. And the context here, crystal clear. They're saying he's a liar. The lie was whether he got the right bottle in the first place.
Yes, but to my colleague's point, it wasn't just a flat out, the customer is lying. There was more to it.
Right.
They explained exactly what occurred. They explained the way in which they process orders. They explained the three-tier system to pull and process an order. The individual stated that he or she printed this and gave the order to the manager, pulled the order, packed it, made sure it was Pappy 23, as we got only one from our distributor. The bottle was delivered, signed for, and checked the bottle. So, I mean, it's more than simply a flat out, the customer is lying.
You're correct, definitely true. Of course, all of those are questions that go to credibility. And this was resolved on a motion to dismiss.
No, they also go to the issue as to whether or not you've made out defamation.
Well, in terms of that, the special information that Garnet was conveying was in its own knowledge. It wasn't conveyed to Citibank. So Citibank doesn't know what the three-tier system is. Citibank's not aware of whether someone is telling the truth and saying they made sure that the right bottle was packaged and delivered.
That was a statement to Citibank.
Exactly.
What I just read was a statement to Citibank.
Right, but Citibank doesn't know if it's true. It's relying on the special knowledge of Garnet. So it's clearly a potentially defamatory statement because it says he's lying about receiving the correct bottle. And that, if true, would mean that in lying about that, he was trying to swindle a...
They never said that. They just simply said that the customer is lying, and then they explained why, in their opinion, the customer was lying. It never stated that there was any fraud being perpetrated or anything like that.
Well, the fraud is implicit in the comment that he was lying.
No,
Well,
go ahead.
is the context important here that city is considering a chargeback request, and they're looking at this? This wasn't printed in a newspaper, just placed on a public blog online. This is the immediate audience was city looking at this and saying, okay, do we believe the merchant, whatever standard they employ? Do we believe the merchant? Do we believe the customer? Are we going to refund the customer? The extent to which he feels he was overcharged. Would the reasonable reader in city's position view that simply as maybe a little hyperbole by the merchant in refuting the customer's claim?
I don't think so, Your Honor, because it is suggesting that what we're dealing with is a simple question of fact, whether the bottle was delivered or not, and that my client was lying about it to try to scam a $3,900
Well, not
credit.
necessarily scam, but obviously he goes to Citibank because he wants a chargeback, right? Because the difference is like over $1,000. The smaller bottle is $22.90, and $22.09, and he paid $38.90. So he wants the chargeback. He goes to Citibank and he says he wants the chargeback. He's disputing the charge. Citibank now goes to Garnet and says, the customer wants their money back, and Garnet says he's lying. He's not entitled to his money back because of X, Y, and Z. So again, in the context, I don't see how you've made out that it would be defamation, wherein they're explaining why they are not going to give him a chargeback.
They're explaining why, but they don't convey the special knowledge that they have to Citi, because Citi doesn't know how this system works. Citi doesn't know.
But this is what they put in the comments section in the dispute portal. This is what is written in the comments section of Citi's dispute portal. This is what Garnet put in that portal, including the customer is lying.
Right. They put all of that in there.
Yes.
And the only inference from the customer is lying here is that the customer is trying to scam Citi.
No, the customer is lying. We never sent him the 15-year. We sent him the 23rd.
And that's why we're
Right.
not
Yes,
gonna,
I interpret it the same way.
And that is why we're not agreeing to a chargeback. But you have additional time on.
Okay. Thank you.
May it please the court. Your Honors, Emery Polat, representing the respondents, Garnet Wine and Liquors. I think just on point with Your Honors' points, the appeal essentially asks the court to expand the New York defamation law by transforming a routine private chargeback dispute with a credit card company to an accusation that's far-fetched of felony larceny. The only statement at issue here is this customer is lying. That statement was submitted, as Your Honor said, in response to a chargeback 2 months later after the purchase. It was also submitted with supporting documentation, including delivery and invoices.
The internal invoice for the PAPI 23.
Correct. So the statement alone with that information, is the merchant's way of responding to Citibank. And Citibank is not somebody that's calling them and asking them. You're not speaking to them personally. Chargebacks happen all the time. So in response to that, in a written response, he provided documentation, and his only comment was, this customer is lying. To misconstrue that and claim that it's felony larceny is just obscene.
Well, with respect to your friend's argument, though, lying is, there's many reasons why, like, for instance, a witness could be incorrect. Maybe the witness is lying. Maybe their memory failed them. Maybe they're mistaken. So lying is a little bit of a loaded word, and he certainly pointed to cases in his brief where courts have found that calling someone a liar can have a defamatory connotation. So why here does does the rest of that comment, that written comment in the portal, why does that shield the word lying here?
So, and precisely to your earlier point, Your Honor, context is important here. The audience is Citibank. It's a financial institution that decides chargebacks every day, thousands. This was not a public statement. It was not a media publication, not a communication to an employer, and not something capable of exposing plaintiff to any kind of public ridicule. It was nothing about plaintiffs standing on society okay, or plaintiff's moral character. The only comment was this customer is lying.
And so what though, if we just take that on its face, what does that mean then? If he's lying with respect to this transaction, does something necessarily follow from that? Did he necessarily engage in criminal activity?
There needs to be some type of reputational harm to, as a result of that comment. And there is none. You can't just construe it as felony larceny just because the merchant is disagreeing with the customer.
But that statement, the customer is lying, doesn't that necessarily suggest that the customer is attempting to commit some type of fraud?
Not necessarily. I think that's...
Well, the customer is going to Citibank and saying, I'm not going to pay the $38.90. I'm not paying the $38.90. He's disputing that charge. So he wants a temporary credit for the $38.90. I'm not paying the $38.90. So again, by saying the customer is lying, you're saying that he's attempting to commit a fraud in that he's trying to get away with, not paying the $38.90 and keeping the Pappy Van Winkle 23 or 15 or whatever it was.
I don't think it could be construed that way, but respectfully, it could also mean that the customer's claims are false. And he said a statement submitting other documentation. He's not saying the customer is a thief. He stole the bottle or did anything or is completely
He didn't
lying.
steal it, he paid for it.
Right.
But now he no longer wants to pay for it. He's stating that he should not have to pay for it because this is not what he ordered.
Yes, and the difference being $1,600 is the difference. He did receive a bottle. Okay, it's not like where the customer accused him of theft and stealing a bottle from one of his.
I'm assuming that there's a difference in taste between the Pappy 23 and the Pappy and the other Pappy 15.
I'm not familiar with it, but I'm sure there is, Your Honor.
There is.
There is? Okay, I was wondering about that. Is it $1,600 worth of a difference? I don't know.
It's
That I
8
don't
years more that
8
it's
years
aged.
more. Okay, thank you.
Not on a judge's salary, I'll tell you that.
Thank you very much.
Thank you, Your Honor. Thank you.
Thank you, Your Honors. I'll be brief. I do want to stress that under the standards set by the Court of Appeals, the action should not be dismissed unless the statement is incapable of holding a defamatory meaning. Here, calling Dr. Friedman a liar about receiving this bottle meant that he was trying to get a credit on false pretenses, and that is larceny. It's a felony larceny here. So, and the case law is also clear that an accusation of larceny is defamatory on its face if it's false. So I respectfully argue that legally this claim is very clear. Garnet accused my client of lying about receiving the bottle that he purchased and trying to get a credit that he was not entitled to, and doing so under false pretenses.
Thank you.
Thank you.
Cook v. New York City Housing Authority. Yes.
May it please the court, good afternoon, Your Honor. I am Clifford Gable of the law firm of Bergman Fields in Lamonsoff, and I represent the appellant Judy Cook. This is an appeal from denial of a petition to file a late notice of claim. And the real issue before the court here, Your Honor, is 66 days reasonable under a petition to file a late, is it a reasonable time to allow a petition to file a late notice of claim under these circumstances? The Court of Appeals decided matter of Newcomb in 2016, and this court that same year decided a case called Richardson versus the New York City Housing Authority, 136 AD 3rd 484, where it allowed a late notice of claim under similar circumstances.
Do we not need some type of an excuse?
A reasonable
excuse as to why there was this, why there was the delay?
We have to, the Court of Appeals said under matter of Newcomb that it's the petitioner's burden initially to show some reasonable excuse, some plausible argument of a reasonable excuse. And in this case, the petitioner, Ms. Cook, made a reasonable argument.
What was that?
She had a terrible fracture of her left shoulder that required surgery. She was hospitalized for 2 days. She had open reduction internal fixation.
So the incident occurred on July 18, 2023. She was back, she underwent surgery on August 11, 2023, and then she was discharged on August 13, 2023.
Yes.
She recovered at home. So from August 2023, she's fine in that she's at home.
And she's living alone without
She's living
assistance.
alone. She has no assistance. She has no assistance of any healthcare provider. She states that she's going to her appointments, by herself. She provided no evidence that she was physically incapacitated during that period of time. As I said, she went to her appointments by herself. Her last appointment, according to the medical records, was August 18, 2023. So why the delay?
Right. Well, but that doesn't mean she was okay. It simply meant she was capable to get around, to go to see her doctors, but she was still
And to go
recovering
to
from.
see a lawyer and/or file a notice of claim.
And she was scheduling doctor's appointments.
Yes, but that was, her position is that she wasn't focused on that. She was focused on her medical care and not on preserving her legal rights. But as soon as she.
Counsel, can I just go back to Richardson for a moment? In Richardson, I believe there was no excuse, and the appellate division said the absence of a reasonable excuse is not standing alone fatal to the application. Under Newcomb, I believe, and the progeny of cases coming out thereafter stated excuse is the lowest level, and in Newcomb, and as well as in Richardson, there was no excuse, and they still found that as long as there was actual knowledge and no substantial prejudice, the other two prongs may have an exercise of discretion for a late notice of claim.
Absolutely, Your Honor, and that's our point. I mean, the fact is, there's no prejudice whatsoever to the respondent in this.
Can I pivot to the pictures, though, because I was a little confused at the pictures. You put into evidence several photos, 23, 24, 25. I think also.
There are several photos.
And also 33. So when were these photos taken? And then 32 is the Google, one of the Google photos.
Photos were taken contemporaneously with the submission of the petition by the petitioner.
But they're undated.
They're undated, but they were submitted in conjunction with the petition.
Can I interrupt you? So
conjunction
is there
with the-
anything in the record to state when these photos were taken? Are you adding to the record, or that's the record points out when these photos were taken?
Right, the record doesn't specifically point out when the photos were taken,
So
but
the question is not so much when the photos were taken. The question is there anything in the record which states when the photos are taken, given the fact that the photos are undated? Is that correct?
correct. But the photos are still submitted in conjunction with the petition by the petitioner, as well as an engineer's analysis, which is also dated and stamped with the seal of the engier. So they're all contemporaneous.
To the Google picture. Did you serve the Google picture pursuant to CPLR 4532B, which is a mechanism which became effective in 2018?
Right, but 4532B is a trial notice. It's a notice to introduce something.
I understand that, but you could do it at a hearing as well, and I've seen it done on motions as well. So you did not do that?
Was not done with that.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon. May it please the court. Patrick Lawless for the respondent, New York City Housing Authority. In addition to failing to present a reasonable excuse for the failure to...
Did you want to discuss Newcomb and, what was the other case?
Richardson.
Richardson?
Thank you.
Well, I'd like to discuss, well, sort of in conjunction with that, the essential element. There's three elements to establish an order entitlement to leave to serve a late notice of claim. Courts have said that the one that usually is the most important is actual knowledge. And in this case, the plaintiff doesn't, the petitioner doesn't establish actual knowledge of the essential facts of the claim within 90 days or a reasonable time thereafter. The Supreme Court properly found that the service of a late notice of claim 2 months after the expiration of the 90-day statutory
counsel-
period was a nullity.
So let's look at the petitioner's petition. Record is 22, paragraph 10. Let me just read it to you, and how do you respond? The annexed photos are a fair and accurate representation of the condition of the exterior front entry step/platform that caused me to fall, and the Google image shows that the condition had existed for years. What's wrong with her testimony, which supports that this condition was extant for the period of time for several years earlier through the petition date?
Well, the Google photographs, it's unknown when they were taken, and you can't even...
You're correct, you're correct. Let's divorce the Google photos. Why isn't her testimony, her petition, which she states that it was present for years, sufficient?
Because there's no corroborating evidence, and cases from this court have found that when you have a claim like that, just the self-serving claim that it's in the same condition by itself is insufficient. There's no
Did
narrative
NYCHA
photographs.
controvert the fact that it's unchanged?
I'm sorry?
Did NYCHA controvert the undisputed fact that it remains unchanged?
Well, NYCHA said the argument is that the self-serving claim that it's unchanged.
That's not my question. That's a separate argument. It's a valid one. But at any point in time in the record, is there an affidavit or some evidence that NYCHA has stated that the condition remained or did not remain unchanged?
No, not in this record. But I'd just also like to point out, though, and it's in our papers, that this court and other courts from the Appellate Division, and this is what sort of distinguishes this from Newcomb, has found that the failure to establish a reasonable excuse coupled with the failure to establish timely actual knowledge of the essential facts of the claim require the denial of the petition, and the issue of prejudice does not even need to be reached.
Can I read you a quote from Richardson, and you answer this, and I know this will be my last question. I know that I'm asking a lot of questions. Although NYCHA did not receive actual notice of the accident until the petition was served, it did not contest petitioner's assertion that the condition of the badly broken sidewalk remains unchanged since the time of the accident, and that there was no witnesses to the accident, so that NYCHA will not be substantially prejudiced by the 8-month delay in providing notice. Here it's between 66 and 81 days.
Yeah, this court recently, in the Brady decision, which is just a couple of months ago, said that the failure to establish a reasonable excuse coupled with the failure to establish actual knowledge required the denial of the petition, and the issue of prejudice need not be reached. That's
So
never been...
that was in matter of Brady. We said that whether NYCHA has been substantially prejudiced by the delay need not be reached.
Yes.
Right? And also in terms of the actual notice, because the actual notice of the defect, because the notice of claim was late, it's a nullity anyhow, right?
Correct.
Thank
Thank
yes, please.
Sir, I just had one question
Once,
for you.
Mr.
before you
Lawless,
sit down.
1 second.
Who has to have actual notice of what?
Well, NYCHA has to have actual knowledge, not just that there may be some sort of defect, but it has to have actual notice of the claim, of the wrong, of a potential action against it. That's what the case law requires, that it's not just notice of a potential wrong, it's notice of the actual facts of the claim.
Of the claim. And so like in some cases in this department where an individual has fallen on NYCHA property, there's been a caretaker or a manager or someone on the premises that they've reported it to or who actually saw the slip and fall.
Correct. Or there's cases where there's been an incident report
Yes.
or some sort of accident report. In this case, that there is none.
So even though we don't have to look to prejudice, the fact remains that NYCHA was not made aware of this incident until December, right? Well, it's a little...
Until when they received the
Until-
untimely notice of the claim.
Thank you.
And Brady was 22 days late, which is a shorter period than your friend mentions in terms
Exactly.
of 66 days late.
Exactly.
Correct?
Thank you.
Correct. Thank you.
Your Honor, while I admit I'm not intimately familiar with the facts in Brady as compared to the facts in Richardson, that doesn't necessarily mean that Richardson is completely abrogated. The facts in Richardson are nearly exactly the same as the facts in Judy Cook. The only difference is Richardson dealt with a broken sidewalk in front of the premises, and Cook deals with a step on the premises, a structural defect on property that is owned by New York City Housing Authority. They should be charged with knowledge and notice of that. They don't have to have knowledge or notice
But see,
of the exact...
counsel, yeah, they do, because the whole reason why you have a notice of claim requirement, and it's a 90-day notice of claim requirement, is so that the city, in this instance NYCHA, knows about the incident and they are able to investigate the incident and see, you know, exactly what occurred at the time. Even your Google photos, there's scaffolding. I mean, it's unclear in terms of the quote-unquote defect.
You can't pick the Google photos, unfortunately.
No, I understand that, but if the photos were taken closer in time to when the incident allegedly occurred, then you wouldn't have such an issue.
Right, but as Judge Hagler...
What do we do before Google Photos?
I don't know.
There was a time before
I don't know
Google
what we did.
Photos, right? I'm sure personal injury attorneys made money, you know, and were able to maintain a livelihood before Google Photos.
We went out and took more photos, maybe.
Polaroid.
Yeah, Polaroid.
The fact is, though, the statute doesn't say 90 days. It says 90 days or a reasonable time thereafter, okay? Is 66 days not a reasonable time thereafter if the court in Richardson allowed a notice of claim 8 months after when the defendant...
So the 66 days, that would be that late notice of claim that was filed without leave of court in December.
Yes, and if not then 81 days when the petition was filed, okay? Either one is much less time than in Richardson. So the question is that reasonable? And why isn't it reasonable when the plaintiff demonstrated there's no prejudice whatsoever because the condition is exactly the same, and she says so in her affirmation or her petition, supported by photographs that she says are contemporaneous, that show the way the condition still looks today? Then under matter of Newcomb, the burden shifts to the respondent to come forward with evidence that they have not brought forward. That's our position.
You have another question?
Court has no further questions.
Thank you both.
Thank you.
North Flats LLC v. Belkin.
May it please this honorable court. This is a single cause of action legal malpractice case with legal fee counterclaims.
So let's take the easier part first. With respect to an account stated, you don't really seriously challenge the paperwork supporting the counterclaim for fees here. The issue is legal malpractice, but you did not seriously or meaningfully counter the account stated claim here on this record.
That's correct, with the qualification that our view, and the court ruled in the first case that we were here before, that the legal malpractice claims and the counterclaims are intertwined. So if you,
I'm not arguing with you, but on this record.
Okay.
So in cutting to the chase, why do you feel it was unreasonable for the defendant to rely on your client's affirmative statement of the principal, Mr. Berkowitz, and the statement and the representation by Mr. Morali, the architect, in saying that they complied with the 7B certification, that it was in full compliance when they made that representation? Why is that unreasonable by your very principle?
Because the issue isn't just whether the architect got it right. The issue is that the controversy was obvious to everyone. It was certainly obvious to the respondents, and the controversy could have been mooted out. It was an expensive controversy, and it meant that while the controversy was pending, it gave the tenants an excuse not to pay rent. And the entire purpose of the representation was so that the North Flats could collect rent during the pendency of the legalization process. And the Loft Board had a legalization process. Ordinarily, you don't collect rent unless you have a certificate of occupancy. However, if you are part of the loft laws, within the loft laws legalization guidelines, and you're complying with the guidelines, you can collect rent. If they had
So
filed
counsel,
for- yes,
can I ask you, this is the part I don't understand.
sure.
The counsel for Belkin Burden relied upon an architect of your client. And I think that your client hired that architect. Is that correct?
Yes, that's correct.
And it was then certified to the Loft Board.
Yes.
That means it was signed off, and I looked at the certification. And if what you want Belkin Burden to do now is to controvert, is to actually state that the certification that was done earlier by the architect is not correct, and therefore we need an extension. Wouldn't that actually put your client in worse position by contradicting an architect?
No, Your Honor. What we are suggesting and what our expert has suggested that Belkin Burden should have done is they should have essentially said, and it's paragraph 94 of the expert affirmation, essentially, look, we think we complied with 7B. We are going to file an extension so that if there is a controversy about it, we're going to look in and make sure we complied. But if
Wouldn't that collaterally attack the veracity of the compliance and put your client in worse trouble? Wouldn't you have to answer why you're collaterally attacking the very document that was certified earlier to the Loft Board?
No, Your Honor, and our expert addressed this squarely in his report, and he cited to the 792 Flushing or 729 Flushing case, which was attached to his report. It basically says you can do both. You can say you've complied, and you can file for an extension. And this way, if there is a controversy, if there's an active controversy, it allows the owner to collect.
Why would
rents.
that be malpractice? That at the very most, you're saying there's two alternative proper methods. One is you could rely upon an architect, or you can make an extension. While an attorney may, in his or her infinite wisdom, go one way, why would that be malpractice? It may not be the preferable method, but certainly a reasonable avenue of relief.
What our expert said, and again, he cited to the case, you do both so that essentially you moot out any controversy. There's no downside to doing that, and in our view, it was malpractice that wasn't done in this case.
You have time on rebuttal. Thank you.
Thank you.
May it please the court, Louis Lindenberg of Belkin Burden Goldman, the respondents appearing pro se. There are a lot of things that my adversary has accused us of doing, but one thing we did, and we did correctly, was to pursue the rent. So just by way of background a little bit, when they came to us and sought Loft Board advice, they weren't getting rent, and that this dated back a few years, and in 2019. So they asked us to advise of a means how they can progress, number one, to legalize the building, and also get paid rent. Because they had owned this building and because they had been in the legalization process for many years, it became clear that they were close or they were at 7B compliance. What that meant to us in giving advice was Well, if you want to, there's a guideline, once a building is registered, and you'd be entitled to get rent and collect rent. Relying on that, and remember, the architect did his inspection on September 9th of 20. The architect certified on November 24th of 90. The architect, and then there was a meeting with Mr. Bobick going back and forth as to whether or not they were convinced that the architect was okay and that which he said is okay because it was leading to the next step. As a result, they filed, and as a result, we brought non-payment proceedings to collect rent. If you recall, in those days, unfortunately, post-COVID, the only way to collect rent was the Supreme Court actions. Mr. Hagler, Judge Hagler, to your point, if we had wanted to withdraw, first of all, as our expert, and by the way, Judge Schulman, you sat on the first time we were before you when there was a prior decision, and in that decision, you were on the bench, there was a recommendation and an order that we obtain an expert opinion. We get an expert on the issue for malpractice.
Confuse me. You're talking about the earlier appeal.
Yes, I'm sorry, on the first appeal. Your Honor. You were on.
Oh, God.
Your Honor, and as a result, we did hire an expert.
And Ms. Alexander came forward and explained, I'm not sure who their expert was. Was it Mr. Frosch?
Well, I was just.
Who was a lawyer practicing.
Yes, and as you recall, and I'm only.
And Ms. Alexander on this record made it clear that it makes no sense when you have this kind of certification to seek an extension.
Absolutely. And even said the likelihood is that we rendered moot. And why? Because in an application for an extension, you need to set forth the grounds upon which you will achieve 7B compliance. You're almost there. You have a few things to do, and you're about to get there, so you make a good faith effort in your application. But it is counterintuitive if you've already reached that guideline and where Judge Layton had previously stated that such an application would not even be warranted, where he said, and that's the law of this case, which was not appealed, where it said, and that extension application are only applicable when deadlines have not yet been complied with. The deadline is that Mr. Morrisy indicated that he had comported, that he stood by his position.
So, counsel, what was the harm taking up the argument of your friend, pleading in the alternative, essentially?
Well, Judge Hagler, it is, first of all, it's not done. Number one, you would have had to have withdrawn the motions for summary judgment. You would have had to go to DOB to undo a certification. This is not just, Morrisy just didn't raise his hand and forgive me, but he actually certified. And as we all know, and by the way, the credit of Mr. Morrisy is something that may have been overlooked, but in conversions of buildings that are loft buildings, they're commercial, and then they end up loft buildings. But every building in New York City that's a residential building must comport with fire safety. So Morrisy wasn't just, he was an architect of 38 years who knew what was required for a building, whether it's being converted or being from the ground up, to be legalized. Just to finish your point.
Oh, that's it. Thank you.
Oh, okay. Thank you.
Just briefly, Article 7B has 38 different provisions in it. Routinely, these are matters of controversy. Routinely, and this is all in the expert report, routinely these are matters where reasonable minds differ. So the idea that the architect certification, no matter how bulletproof we might have thought it was, would be the final word. That's just not the case in loft law practice. And the gist of this is, again, Pleading in the alternative is what the litigators would call it. It is the standard in loft law practice. We had an expert. He cited a precedent within the loft board. Their expert did not cite any precedent. We are all supposed to take her word for it, evidently. And so we think it's a classic battle of the experts, and we believe the court should reverse. And when it reverses, it should reverse the counterclaim as well, so that both the claim and the counterclaim can be tried. Thank you.
Thank you. U.S. Bank v. Gordon.
Good afternoon, Your Honorable Judges. If it pleases the court, I represent the respondents, defendants in this action. Your Honor, my comments will be short since the appellant is absent, but I would just remind the court that none of the departments so far have ruled the impact of FAPA unconstitutional. Particularly this court, the first department. There are a few cases starting in 2024. We start with Bayview Loan Services LLC versus Dalal, November 19, 2024. Wilmington Trust N.A. versus Farkas in November 21, 2024. The Bank of New York Mellon versus Del Rio, December 17, 2024. And Del Rio went even further to hold that the taking clause was not violated. And it culminated recently, November, December, with the Van Dyke case, Van Dyke versus US Bank. Your Honor, when we look at the appellant's reply brief, which I did not have time, so probably that's my short reply, that he mentioned he's different because of the deacceleration letter that dated August 4th. And the deacceleration letter, without FAPA, I want to say that it was pretextual, and it wasn't meant at all a genuine effort to reopen the loan. If you look at R570 and the case law, if you look at GMAT versus Cater, it tells us if there is no invoices, no demand for payment, nothing tells us how much it is owed. So if you look at R70, you will see no invoices. You will not know what amount he has to pay to bring back the loan into good standing. There is nothing there telling us that the loan is genuinely reopened for the respondents to make payments. So as such, based on the law, it is pretextual, and it cannot have no impact in deaccelerating the loan. Secondly, he asked this court to apply the previous law, because when they filed it in 2017, the law, FAPA, was not existent at the time. We can appreciate the facts of this case. The first foreclosure action was filed in April 21, 2011. And the second foreclosure action was filed on July 28, 2017. So we can agree the second foreclosure action is definitely time bad because it's more than 6 years. The appellant saying, no, my deacceleration letter, when you apply the previous law, stall or toll or reset.
So we can agree that Engel was overruled by Van Dyke and Local 13, correct?
Yes. But I want to add one more for me to close. When the second department was deciding GMAC Mortgage LLC versus COME in 2017, that had to deal with the statute of limitation, where they say, hey, even though you did not put it as an affirmative defense, it does not waive. It follows the CPLR 4211A subsection 2, 7 and 10, where it cannot be waived. So they put it on the same footing, and they had the 1132A, where they started the issue of standing. And in this GMAC case, the bank wanted to say, hey, since this case started, when this case was being considered, the law at the time, they had to actually plead the affirmative defense of standing. So now you are deciding the case, and this new law is there, you should not apply the new law.
Thank you.
And, well, I just want to...
I know, but that red light is on there, so.
Okay.
But thank you very much. Thank you for your argument. Last case for argument, Lamb Pearl Street v. Renaldi. Is there an appellant?
I am the appellant. We can admit her pro
I think it's pro hack or something.
Okay, go ahead.
Good afternoon, Your Honor. May it please the court. My name is Christopher Conway. I'm an attorney in New York. I'm here as of counsel for the Sheps Law Group of Huntington, New York. I ask this court to please admit and allow Ms. Erin Rodenhouse of Dennenberg Tuffley to participate and argue the appellate case today. We have submitted a letter to the clerk.
Application is granted. Thank you. You may
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. My name is Todd Shaw. I'm here for the appellants. I'm going to be brief in as much as the respondent, Maine Electrical, who is the true opponent to this appellate brief, is not here.
You represent whom?
The Renaldi defendants, Anthony
Renaldi,
Renaldi
okay.
LLC and Renaldi Group LLC. The issue at bay here is that the lower court issued a decision on summary judgment which correctly granted our clients conditional contractual indemnity, but went outside the strict terms of the contract and granted our clients conditional contractual indemnity conditioned on our clients proving negligence
And
against.
there's no negligent trigger in the very provision of the contract.
That's the only issue.
Contract doesn't talk about negligence.
The contract does not talk about negligence. I would just submit a case squarely on point which dealt with this issue was matter of New York City asbestos litigation, where the court said, since the reference in the indemnification provisions to any act or omission did not specify that the action or omission must have constituted negligence, the triggering of the obligation to indemnify was not contingent upon proof that that party had acted
But
negligently.
you do agree that very provision does provide for the possibility, and I use the terms colloquially, apportionment of liability.
Correct, and that's the law, but yes.
If you can find that there was some kind of act or omission in the work performed, right?
I'm sorry,
If there's a determination that there was some type of act or omission.
correct, it's just a lower standard than negligence.
Then negligence, exactly.
That's
Thank
really all
you.
I have. Thank you.
Thank you. May it please the court, Erin Rodenhouse appearing on behalf of the plaintiff respondents, Lamb Pearl Street Hotel and their subrogated insurer, Endurance American Insurance Company. I will be very brief. My friend has not put into issue the portion of the order in which the lower court saved our negligence claims. And so I would ask that if this court is intending on disturbing the January 16 order, they would issue a very narrow ruling only on the indemnification, since the negligence issues.
So you do concede that there's nothing that talks of negligence in the contract?
So I don't take a position on the appeal, the questions presented between the appellant and respondent, Maine Electrical. I'm just here to make sure that my client's interests are protected. We survived Renaldi's summary judgment motion. Our negligence and gross negligence claims are preserved in that order, and they are not putting that at issue in this appeal. So any order that, if the court is going to disturb the January 16 order regarding the indemnification issue, I would just ask that it was just strictly construed to that.
Thank you.
Thank
Thank you
you.
both.